Stop everything you're doing and pay very close attention. On June 25, 2025, USCIS announced the end of its biometric reuse policy, requiring all immigration applicants to appear in person for new fingerprint and photo capture, regardless of how recently they provided biometrics, potentially affecting over 3 million pending applications and creating massive scheduling backlogs at application support centers nationwide. If you have a pending naturalization application, adjustment of status, work permit renewal, or any other USCIS benefit application filed in the past year, if you're planning to file any immigration application in the next 12 months, or if you've already provided biometrics for a previous application and expected them to be reused for your current case, what I'm about to tell you will completely change your timeline, could delay your application by 6 to 12 months, and requires immediate action to secure biometrics appointments before the system becomes completely overwhelmed. This isn't a minor procedural change. This is a fundamental shift in how USCIS processes applications that will create unprecedented appointment backlogs and could derail thousands of cases where time-sensitive issues like status expiration or aging out depend on timely processing. Stay with me for the next 30 minutes, because I'm going to break down exactly what the biometric reuse policy was and why eliminating it is so disruptive, what the new requirements mean for your application, how the scheduling system works and why it's about to collapse, who's most affected and what risks you face, and the 3 critical steps you must take immediately to navigate this crisis. Let me start with what biometrics are in the immigration context, because understanding the baseline process helps you grasp why this policy change creates such chaos. Biometrics in USCIS processing refers to fingerprints, photographs, and sometimes signatures that immigration applicants must provide, so USCIS can conduct background checks, verify identity, and create secure records. When you file certain applications with USCIS, adjustment of status for a green card, naturalization for citizenship, initial or renewal applications for work authorization, asylum applications, and various other benefit applications, USCIS requires you to attend a biometrics appointment at one of their application support centers, located throughout the United States. At the appointment, which typically lasts 15 to 30 minutes, a USCIS technician captures your fingerprints using digital scanning equipment, takes your photograph, and records your signature. This biometric data is submitted to the FBI and other law enforcement databases to check for criminal history, terrorist watch lists, and other security concerns. The biometrics are also used to verify that you're the same person who filed the application and to create your permanent immigration record if your application is approved. For most applicants, the biometrics appointment has been a routine procedural step that happens a few weeks or months after filing their application, and once completed, it allows USCIS to proceed with background checks and adjudication. Here's where the reuse policy comes in. For decades, USCIS has had a policy allowing them to reuse biometrics from previous applications if those biometrics were captured recently enough, typically within the past 15 months, and if the new application didn't require additional or updated security screenings. This reuse policy was implemented to increase efficiency, reduce costs, and minimize burden on applicants who were filing multiple applications in succession. For example, if you filed for adjustment of status and provided biometrics, and then 3 months later you filed for advanced parole, USCIS would reuse your adjustment biometrics for the advanced parole application, rather than requiring you to appear for a second appointment. Or if you filed for naturalization 10 months after receiving your green card, and you'd provided biometrics for the green card application, USCIS would often reuse those biometrics for your citizenship application. The reuse policy was particularly important for applicants who file multiple related applications simultaneously or in quick succession. Things like filing I-485 adjustment, I-765 work authorization, and I-131 advance parole all together, or filing naturalization shortly after receiving conditional residence removal. Under the reuse policy, you'd provide biometrics once, and USCIS would apply them to all your pending applications. This saved applicants from having to take multiple days off work, travel to application support centers multiple times, and pay for multiple appointments if fees were charged. It also saved USCIS resources by not duplicating biometric captures that had been done recently. The June 25th announcement eliminates the reuse policy effective September 1, 2025. Starting on that date, every application will require fresh biometrics regardless of how recently you provided them for a different application. If you filed adjustment of status and provided biometrics in July, and you file for a work permit renewal in December, you'll have to appear for new biometrics for the work permit even though your adjustment biometrics are only 5 months old. If you're a green card holder who files for naturalization, you'll have to provide new biometrics for the citizenship application, even though you provided biometrics for your green card application just 2 years earlier. Every application, every time, requires a new biometrics appointment. USCIS's stated rationale for eliminating reuse is enhanced security and fraud prevention. The announcement claims that biometric technology has improved significantly in recent years, that more sophisticated security screening requires the most current biometric data, and that requiring fresh biometrics for each application reduces the risk of identity fraud and ensures the highest level of accuracy in background checks. The announcement also mentions that eliminating reuse will create more consistency in processing, because every application will follow the same biometric capture procedures. But immigration attorneys, applicants, and even some USCIS employees are questioning whether these stated rationales justify the massive disruption this policy change will cause. The real impact of eliminating reuse is that the number of biometrics appointments USCIS must schedule and process will increase by an estimated 50 to 70%. USCIS currently conducts approximately 4 million biometrics appointments per year across its 130 application support centers nationwide. Under the new no reuse policy, that number could jump to 6 to 7 million appointments annually. The application support centers don't have the capacity to handle that volume. The scheduling system is already strained, and the result will be appointment backlogs that delay applications by many months. Let me give you a concrete example of what this means. Chen is a green card holder who's been a permanent resident for 5 years. He files his N400 naturalization application in August 2025, and under the old reuse policy, USCIS would have likely reused his biometrics from his green card application if they were recent enough, or at most he'd wait 2 to 3 months for a biometrics appointment. But under the new policy, taking effect September 1st, Chen must provide fresh biometrics regardless of his previous biometric captures. He receives his biometrics appointment notice in mid-September, scheduling his appointment for February 2026, 5 months after filing his application. This delay alone adds 5 months to his naturalization timeline, and during those 5 months, USCIS can't complete his background check, can't schedule his interview, can't move his case forward at all. Everything is frozen, waiting for biometrics. Or consider Priya, who files concurrent I-485 adjustment of status, I-765 employment authorization, and I-131 advance parole applications in October 2025. Under the old reuse policy, she'd provide biometrics once, and USCIS would apply them to all 3 applications. Under the new policy, she technically needs separate biometrics appointments for each application. USCIS has stated they'll try to schedule concurrent appointments for related applications filed together, but immigration attorneys are reporting that the scheduling system doesn't always recognize related applications and sometimes schedules separate appointments weeks or months apart. Priya could end up having to appear for biometrics 3 different times. Or she could face a situation where one application moves forward with biometrics while the others remain pending, waiting for appointments to be scheduled. Let me walk you through what application support centers are and how they operate, because understanding the infrastructure helps you grasp why capacity is such a critical issue. USCIS operates approximately 130 application support centers across the United States, typically located in federal buildings or dedicated facilities in major metropolitan areas. Some states have multiple ASCs. California has about 15, Texas has about 12, New York has about 8, while smaller states might have only 1 or 2. If you live in a rural area, you might have to travel several hours to reach the nearest ASC. Each ASC has a limited number of biometric capture stations, typically 4 to 12 stations, depending on the size of the facility, and each station can process approximately 4 to 6 appointments per hour. That means a medium-size ASC with 8 stations operating 8 hours per day can theoretically process 250 to 400 appointments per day. Multiply that by the approximately 130 ASCs nationwide operating 5 days per week, and you get a theoretical capacity of about 160,000 to 200,000 appointments per week nationally, or roughly 8 to 10 million appointments per year if everything runs at full capacity with no downtime. But that's theoretical maximum capacity. In reality, ASCs operate well below capacity due to staffing shortages, equipment maintenance, appointment no-shows, processing delays, and various other factors. Current actual capacity is probably closer to 4 to 5 million appointments per year. That was sufficient when USCIS was reusing biometrics for maybe 30 to 40% of applications, meaning only 60 to 70% of filed applications required new biometrics appointments. But when 100% of applications require new appointments, starting September 1st, the math simply doesn't work. There aren't enough appointment slots to meet the demand. This is general information, not legal advice. But let me tell you what's already happening at ASCs in late June and early July 2025, as word has spread about the policy change. Immigration attorneys are reporting that appointment wait times have already increased from the historical average of 6 to 8 weeks to current waits of 12 to 16 weeks in many locations. Some ASCs in high-volume areas like Los Angeles, New York, Miami, and Houston are scheduling appointments 4 to 5 months out, and this is before the September 1st policy change even takes effect. This is just the anticipatory surge, as people who filed applications recently are now being scheduled for appointments under the new rules. Once September 1st hits, and every application requires fresh biometrics, attorneys are predicting that appointment wait times could extend to 6 to 9 months in high-volume areas, and possibly even longer in the winter and spring of 2026 as the backlog compounds. Think about what a 6-month biometrics delay means for different types of applications. For naturalization, it adds 6 months to a process that already takes 12 to 18 months, pushing your citizenship timeline to 18 to 24 months. For adjustment of status, it delays everything. You can't get your work authorization approved, you can't get advanced parole approved, and USCIS can't complete your background check or schedule your interview until biometrics are captured. For work permit renewals, a 6-month biometrics delay is catastrophic. If your current employment authorization document expires in December and you file your renewal application in October, giving yourself the recommended 60 days advance notice, but you don't get a biometrics appointment until April, your EAD will expire and you'll lose work authorization for 4 months while waiting for the appointment, and then additional months while USCIS processes your renewal after biometrics are finally captured. Even though USCIS allows automatic extensions of work authorization for certain categories when timely renewal applications are filed, those extensions only last 180 days. And if biometrics delays push your case past 180 days, you could lose work authorization entirely. Let me give you another scenario that shows the cascading problems. Ahmed is on H-1B status with his wife and young child as H-4 dependents. His employer is sponsoring him for a green card. Ahmed files his I-485 adjustment application, his wife files her derivative I-485, and they both file I-765 applications for work authorization, so Ahmed's wife can work while their cases are pending. Under the old reuse policy, Ahmed and his wife would each provide biometrics once, probably at the same appointment, and those biometrics would be used for both their adjustment applications and their work permit applications. Under the new policy, Ahmed needs biometrics for his adjustment and separate biometrics for his work permit. His wife needs biometrics for her adjustment and separate biometrics for her work permit. That's 4 total biometrics appointments for the household. The scheduling system assigns Ahmed's adjustment biometrics for December, his wife's adjustment biometrics for January, Ahmed's work permit biometrics for February, and his wife's work permit biometrics for March. None of their applications can move forward until the respective biometrics are captured. Ahmed's wife was counting on getting work authorization within 4 to 6 months so she could contribute to family income, but now she's looking at potentially 8 to 10 months before her work permit is approved because of the biometrics delays. The financial strain on the family is enormous. Now, let's talk about who's most affected by this policy change and why certain populations face disproportionate harm. First, people in areas with limited ASC access. Rural areas, smaller cities, states with few ASCs face longer travel burdens and longer wait times because their nearest ASC has to serve a large geographic area and has limited capacity. If you live in rural Montana and the nearest ASC is 200 miles away in Billings, having to make that 400-mile round trip multiple times for separate biometrics appointments is a significant hardship in terms of time, expense, and logistics. Second, people with disabilities or health conditions that make travel difficult now face multiple trips to ASCs, when previously they might have had biometrics captured once and reused. USCIS does offer mobile biometric services for people who are homebound or institutionalized, but those services have limited capacity and long wait times, and you have to prove that you genuinely cannot travel to an ASC, which can be difficult for people with conditions that make travel very difficult, but not literally impossible. Third, families filing multiple related applications, like Ahmed's family in the example above, now face coordination challenges of scheduling multiple appointments, taking multiple days off work, arranging childcare multiple times, and dealing with the complexity of tracking which biometrics go with which applications. Immigration attorneys are reporting increased confusion among applicants about which appointment notices correspond to which applications, particularly when multiple family members have multiple applications pending simultaneously. Fourth, applicants in time-sensitive situations, people whose current status is expiring, people approaching age out for dependent benefits, people with job offers contingent on receiving work authorization by a certain date, now face the very real possibility that biometrics delays will cause them to lose status, age out, or miss critical deadlines. The predictability of timelines has evaporated, making it nearly impossible to plan anything with confidence. Let me address what USCIS is saying about appointment capacity and wait times. The June 25th announcement acknowledged that eliminating reuse will increase demand for appointments, but claimed that USCIS is taking steps to expand capacity, including hiring additional biometric technicians, extending operating hours at high-volume ASCs, and implementing more efficient scheduling algorithms. USCIS stated that they don't expect appointment wait times to increase significantly, and that any temporary delays during the transition period will be resolved by early 2026 as the system adjusts. Immigration attorneys and USCIS employees are deeply skeptical of these claims. Hiring and training new biometric technicians takes months, and government hiring processes are notoriously slow. Extending operating hours requires additional funding for overtime and facility costs, and it's unclear whether USCIS has secured that funding. And improving scheduling algorithms doesn't create more physical appointment slots when ASCs are already operating near capacity. The consensus among people who understand USCIS operations is that the agency is vastly underestimating the disruption this policy change will cause and is not adequately preparing for the capacity crisis that's coming. There's also the question of whether this policy change is actually necessary for the stated security and fraud prevention goals, or whether it's another administrative mechanism for slowing down and restricting immigration processing. Enhanced biometric technology and more sophisticated screening can be applied to reused biometrics. There's no technical reason why USCIS needs to recapture fingerprints and photos every few months to conduct thorough background checks. The FBI and other agencies maintain biometric databases that can be checked and rechecked using existing biometric data. Requiring fresh captures for every application doesn't meaningfully enhance security, but it does create significant delays and barriers to immigration benefits. We just covered how this policy change appears designed to create delays rather than enhance security. And now we need to talk about what you can actually do to minimize the impact on your case. What strategies exist for navigating the appointment backlog, and what this means for the future of USCIS processing. Let me start with the most urgent practical question. If you're planning to file an immigration application in the next few months, what should you do to minimize biometrics delays? The first and most important strategy is timing. If you can file your application before September 1st, 2025, do it. Applications filed before the policy change takes effect will be processed under the old reuse policy, meaning if you have recent biometrics from another application, USCIS may reuse them, and you won't need a new appointment. Even if reuse doesn't apply to your case, applications filed in July or August will enter the scheduling queue before the September surge, giving you a better chance of getting an earlier appointment. But here's the critical caveat. Only file before September 1st if you're actually ready to file with a complete, properly prepared application. Do not rush to file an incomplete or deficient application just to beat the deadline. Because as we discussed in previous videos, USCIS is now rejecting incomplete applications without RFE opportunities, and having your application rejected means you lose your filing date and your fees, and you have to start over, which defeats the purpose of filing early. The strategy is to file as early as possible with a complete bulletproof application. If you can't file before September 1st, the next best strategy is to file as early in September as possible, because appointment scheduling is generally first come, first served based on application receipt date. An application filed September 2nd will likely get scheduled before an application filed September 20th, all else being equal. So if your case will be ready in September, file on the 1st or 2nd, not later in the month. Now, let's talk about the 3 critical steps you must take immediately if you have a pending application or if you're planning to file soon. Step 1. If you've already filed an application and you're waiting for your biometrics appointment notice, Monitor your case status obsessively and respond immediately when the notice arrives. USCIS sends biometrics appointment notices by mail, and they typically give you 2 to 3 weeks advance notice of your appointment date. The notice will specify the date, time, and location of your appointment. You must appear at that exact time. If you miss your appointment, your application could be delayed by many additional months while USCIS reschedules you. And in some cases, missing a biometrics appointment without good cause can result in your application being denied. If the scheduled appointment date creates a genuine hardship, you'll be out of the country, you have a medical emergency, you have a conflicting court date, you can request a rescheduling by following the instructions on the notice. But be aware that rescheduling can delay your case by several months under current conditions. Only reschedule if you absolutely must, and if you do reschedule, provide clear documentation of why the original date was impossible. When you go to your biometrics appointment, bring your appointment notice, your passport or other government-issued photo ID, and your green card if you're a permanent resident. Arrive at least 15 minutes early. The actual biometrics capture typically takes only 10 to 15 minutes once you're called, but there can be waiting time if the ASC is busy. Follow all instructions from USCIS staff, and if there are any problems during the appointment, equipment malfunction, issues with your fingerprints not capturing properly, anything unusual, ask the staff what it means for your application and whether you need to take any follow-up action. Step 2. If you're filing an application soon and you know you'll need biometrics, plan your entire timeline around the assumption that biometrics will take 6 months, not 6 weeks. This is particularly critical for work permit renewals and for any situation where you have time-sensitive deadlines. If your current work authorization expires in March 2026, don't file your renewal application in January, assuming you'll have the new card by March. File in August or September of 2025, giving yourself 6 to 7 months of buffer time. Yes, this means filing your renewal application when your current card still has 6 or 7 months of validity remaining, which feels unnecessarily early, but under the current backlog conditions, this is the only way to ensure you don't lose work authorization during the renewal process. For naturalization applications, understand that you're now looking at a total timeline of 18 to 24 months from filing to oath ceremony in most cases, with 6 to 9 months of that being biometrics and background check delays. Plan your citizenship application timeline accordingly, and don't make life decisions contingent on receiving citizenship by a specific date, unless you have substantial buffer time built in. For adjustment of status applications, recognize that biometrics delays will push your entire case back. You won't get work authorization approved, you won't get advance parole approved, and you won't be scheduled for your interview until months after biometrics are captured. If you're in a situation where you need work authorization or travel permission urgently, explore whether you have alternative options, like maintaining H-1B status for work authorization, or applying for advance parole well in advance if you have pending adjustment and anticipate needing to travel. Step 3. If you're in a genuinely urgent situation where biometrics delays would cause severe hardship, loss of critical employment, medical emergencies, humanitarian crises, consult with an immigration attorney about requesting expedited biometrics processing. USCIS does have a process for expediting biometrics appointments in extraordinary circumstances, though the bar is very high and approvals are rare. You must demonstrate that the delay would cause extreme hardship beyond normal inconvenience, and you must provide extensive documentation supporting your expedite request. Expedite requests are typically submitted through USCIS's contact center or through your local field office. They require detailed letters explaining the urgent circumstances, supporting documentation like medical records, employer letters, court orders, or other evidence, and legal arguments about why your case qualifies for expedited processing. Most expedite requests are denied, but in truly extraordinary situations, they can be granted. An experienced immigration attorney can help you evaluate whether your situation qualifies for an expedite request and can prepare the strongest possible request package. Let me address what legal challenges exist to this biometric reuse policy change. As of early July 2025, the American Immigration Lawyers Association has announced it's evaluating potential legal challenges to the policy, but no lawsuits have been filed yet. The challenge AILA faces is that biometric reuse was always a discretionary policy rather than a legal requirement. USCIS has always had the authority to require fresh biometrics for every application. They just chose not to exercise that authority for efficiency reasons. Eliminating a discretionary policy is much harder to challenge legally than implementing a new requirement that contradicts statute or regulation. Potential grounds for challenge include arguing that eliminating reuse without expanding ASC capacity violates the Administrative Procedure Act because it will cause unreasonable processing delays that effectively deny applicants their rights to timely adjudication. Another potential argument is that the policy change was implemented without proper notice and comment rulemaking, though USCIS will likely argue that this is an operational decision about internal procedures rather than a substantive rule change requiring rulemaking. A third potential argument is that the lack of capacity planning and the foreseeable harm to applicants from massive delays constitutes arbitrary and capricious agency action. These legal theories are plausible, but not slam dunks, and litigation would take many months or years to resolve. In the meantime, the policy would remain in effect and applicants would continue to face the consequences. You cannot rely on litigation to solve this problem. You need to plan and act based on the current reality. Here's the legal disclaimer. This is general information about USCIS biometric requirements and the policy changes taking effect September 1, 2025. This is not legal advice, and it's not a substitute for consulting with a qualified immigration attorney about your specific case. Biometric requirements vary by application type. Appointment scheduling timelines depend on many factors, including your location, and every applicant's situation is unique. You need personalized legal guidance to navigate your specific immigration case under these new policies. Let me leave you with this. The elimination of biometric reuse is yet another example of USCIS implementing policies that create delays and barriers to immigration benefits without legitimate justification. The stated security rationales don't withstand scrutiny. Recapturing fingerprints every few months doesn't enhance security in any meaningful way, when those fingerprints can be checked against databases using existing captures. What this policy does accomplish is slowing down processing, creating scheduling nightmares, and making the immigration system more difficult to navigate. This is consistent with the broader pattern we've been documenting throughout these videos. Every aspect of immigration processing is being made more difficult, more time-consuming, and more likely to result in delays or denials. From eliminating favorable discretion to creating intentional I-130 backlogs. From suspending NVC cases to implementing impossible documentation requirements. From conducting medical screening designed to find disqualifying conditions to now requiring redundant biometrics that create massive scheduling bottlenecks. Every change serves the goal of restricting immigration through administrative obstacles. If you're navigating the immigration system right now, you need to understand that nothing is quick, nothing is simple, and nothing can be taken for granted. A routine biometrics appointment that used to be scheduled within 6 weeks and was a minor procedural step is now a 6-month delay that can derail your entire case if you haven't planned for it. You need to build substantial buffer time into every timeline. You need to file applications earlier than you think necessary, and you need to prepare for the worst-case scenario at every stage. If this video has helped you understand the biometric reuse policy change and what you need to do to protect your application timeline, hit that like button right now. Subscribe to this channel for ongoing coverage of USCIS operational changes and for practical guidance on navigating delays and backlogs. Share this video with anyone who has pending applications or who's planning to file, because they need to understand these timeline realities before making plans that depend on timely USCIS processing. Your immigration application, your timeline, and your ability to plan your life all depend on understanding and adapting to these new realities. File early, plan for long delays, build substantial buffer time into every deadline, and get professional legal help to navigate the increasingly complex and hostile immigration system. This is too important to leave to chance, and the consequences of miscalculating timelines are too severe to risk.